Today we're going to be talking about trademarks and the trademark application process in Canada in 6 steps. Ent Counsel is a law firm for creatives and entrepreneurs in the areas of social media law, technology, entertainment, copyright, and trademarks. Step 1. Filing a trademark application. A trademark registration is obtained to protect a brand name, logo, or slogan. A registration gives you rights across Canada. A trademark applicant must be a person entitled to registration, also referred to as legal entities. The person or legal entity may be an individual, partnership, trade union, association, joint venture, or corporation. A predecessor and title must be named on the application, indicating previous ownership. Do a preliminary search of the existing trademarks first to make sure your trademark or brand name is available. And you can do this through simple internet searches and a nuanced search of business names to see if others are using your proposed name or a similar name. A lawyer or agent can also search the trademarks database for you. The trademark application can be filed online with a $250 filing fee through a trademark agent or lawyer. Now, you can do this yourself, but it's highly recommended you have it done properly. You will need to pay a separate fee to the agent or lawyer. Once your trademark application is filed, you will get a filing date and application number, usually within 1 day. The good news is now you get priority over your proposed trademark on that filing date, even though your trademark is pending registration. You also get a priority date for an application filed in another country within 6 months of the first filing. The trademark application will now be entered into the Canadian Trademarks database. You will then receive a formal filing acknowledgement and proof sheet with information about the application. Step 2. The examination process. Next, you will hear from the trademarks examiner who will provide an examiner's report. This can take approximately anywhere from 6 months to 1 year. The application was reviewed by the examiner to ensure compliance with the Trademarks Act and regulations, to determine if it can be approved for advertisement in the Trademarks Journal. The trademarks examiner will notify you with an office action of any objections on your application, such as whether your description of your wares or services are too broad, unclear, or need to be revised. The examiner may ask you to disclaim the rights to the exclusive use of certain words in your trademark. The examiner will conduct a search of the register to see if there are any prior applications or registrations that are confusing with your application. You can respond back to the examiner addressing these concerns. If the examiner is not satisfied with your response, you will receive a letter that your application has been refused, along with a list of the grounds for refusal. Now, you may amend certain aspects of the application to address the examiner's concerns, and you can also submit arguments to the examiner for reasons why the application should not be amended. The application gets prosecuted back and forth between the applicant or agent and the examiner until the notice of allowance stage. This back and forth process can take several months to a year or more. If the examiner does not move your application forward, you can appeal to the Federal Court of Canada. Step 3. The pre-publication search. The examiner conducts a second search to make sure there are no trademarks that are registered or applied for that could conflict with your proposed mark. Step 4. Publication. The application is now advertised and published in the Trademarks Journal to allow for any oppositions or challenges to your application. The Trademarks Journal provides your name, address, file number, filing date, the trademark, whether the application is based on use or proposed use, any disclaimers, claims, and the goods and services for which the trademarks are used or proposed to be used in association with. Advertising allows a party to object to a trademark before it's approved. Step 5. Opposition. An application advertised in the Trademark Journal may be opposed by a party with valid grounds within 2 months of the publication date. They must file a statement of opposition or request an extension of time to oppose along with payment of a fee. Step 6, allowance and registration. This is our last step. If the application is not opposed or if you are successful in an opposition proceeding, the application will be allowed for registration and you will receive a notice. The trademark can be registered once the government fee of $200 is paid. If your application or part of it was based on proposed use, you will now need to provide a sworn declaration stating you have commenced use of the trademarks with respect to those goods and services. You can request extensions of time if you haven't used the mark with a particular good or service. You will then be issued a certificate of registration and your trademark will be entered into the Register of Trademarks. A registration fee, and if you file based on proposed use, a declaration of use indicating the mark is being used in association with the wares and services must now be provided. You will then obtain an official registration certificate, usually about 4 weeks later. The timeline for the entire process can vary anywhere from 12 months to 18 months or more from the date of filing. Your registration is valid for 15 years and renewable every 15 years after payment of a renewal fee to the government. Congratulations, as you now have exclusive use to your trademark for those goods and services. If you need help with your application, feel free to contact us. This was not intended to be legal advice, but just general information on the trademark process. Contact us at vandana@entcounsel.com for more information. And if you want to obtain this slide deck, go to www.entcounsel.com/blog/trade-mark-registration. Thank you very much.